Wildstar, dated the same date. I've also received correspondence from Charles Ham, dated February 23rd, 2021. Angelique Moses, dated March 1st, 2021. Dustin Ward, dated March 2nd, 2021. Adam Petty, dated March 3rd, 2021. Mary Beth Yuskevich, MD, dated March 6th, 2021. Caitlin Peters, dated March 7th, 2021. Martha Lambden, dated March 9th, 2021. And Jeremy Cohen, dated March 11th, 2021. And I've also reviewed correspondence which contained copies of Twitter posts, which was also attached to the people's sentencing brief. So on behalf of the people, are there any other comments or materials or witnesses that people would like to submit for sentencing purposes?
Your Honor, I believe I've outlined all my positions adequately in my sentencing brief. If the court has any questions about anything specific or would like to hear argument, I'm happy to address that, but otherwise I'll submit.
All right, well, let me hear from defense counsel to hear anything else they want to add. If you want to respond to that, you may do so. Go ahead, counsel.
Yes, Your Honor. First, I'd like for Mr. Wildstar, he has his statement that he submitted. He'd like to read it into the record. I'd also like to read Ms. Wildstar's statement into the record.
All right, Mr. Wildstar, whenever you're ready, you may proceed.
Morning, Judge Knox. Are you able to hear me clearly?
I am able to hear you. If you want to, you can move the microphone closer.
How about that?
That's fine.
All right. As I said, good morning, Judge Knox. I'm sure by now that you already have an impression of what type of man that I am in your head. Despite some of the other less flattering statements made about me during the trial, I hope that you've gathered that I am a man of principle, conviction, and integrity. You strike me as someone that appreciates and exhibits these qualities himself, especially after learning about your presiding over the People versus Red Key and Beers cases. These two citizen journalists were vindicated for exercising their constitutionally protected rights because you chose to dismiss their cases. Had they been prosecuted just as I have, who knows what the outcome may have been. But since the jury has made their verdict, the final decision on if I am guilty or not is yours to make. If you agree with their decision, then I would ask that you express leniency on me as you did with Red Key and Beers. I am now living in Fresno and do not plan on being in Orange County anytime soon, so avoiding an arrest should be pretty easy. I'm also a father of an 18-month-old child and am teaching my son the lessons I've learned in life to keep him from avoiding trouble. Educating him about this would be extremely difficult to do from inside a jail cell. At this unprecedented time in our country, keeping families together should be a top priority, so allowing me to remain at home where I belong would also protect me, them, and others from a life-threatening contagion. As a tax-paying citizen, I would have to say that putting violent offenders behind bars would be money well spent, rather than incarcerating people convicted of nonviolent, victimless crimes, such as myself. A lesser sentencing, such as probation or even community service or even a small fine, would also be welcomed. Time served should also be considered, since I did indeed spend 9 days in county jail already for the December 2019 court appearance, missing my son's first Christmas. On a possible chance that if you do not agree with their verdict, I ask that you please dismiss the charges completely along with the associated fees. This would indeed be a miracle, but I am a man of faith and believe in the higher good of mankind. This is partly the reason why I myself have sought to serve as a public representative and am doing so now as a candidate for California governor. In the event that I am elected, your graciousness and egalitarianism most certainly will not be forgotten. Thank you for your time, and may the light of God and liberty shine on you.
Thank you, Mr. Wildstar. Counsel?
Yes, the letter from Crystal Wildstar, Nickolas Wildstar's wife. I'm Crystal Wildstar, Nickolas Wildstar's wife of the defendant in case number 19CM06747. I am writing to you in response to this case. I am deeply saddened by the results of this trial and want to reach out to you in hopes that you understand the magnitude of pain and hurt this caused our family. We just had our firstborn son, who is very attached to his father, Nickolas Wildstar, who is a great father and husband. I'm asking for leniency and understanding during his sentencing. Him not being present in our lives would be a devastating blow mentally, physically, and spiritually, not only to my husband, but to our family. This negative impact would leave me on my own to provide and care for our child, which would add more strain to our family, especially during these uncertain times. I understand that you may have felt that you have been acting within your role as a magistrate of the court, and that this is the jury's decision. However, you can still exercise compassion from the bench in this case. My husband, Nickolas Wildstar, felt he was within his constitutional rights to do as he did. He isn't a bad person, but a loving one who is passionate about liberty and helping others. You may feel his methods are a bit unorthodox, but that doesn't make him a criminal. And I'm hoping that you can see that during this upcoming hearing, please act with love and mercy shall follow you. I pray that the decision will keep our family together during this pandemic and will be made in the upcoming hearing. The hopes and prayers of myself, friends, and family are counting on it. Thank you for taking the time to read this as well as consider this. I thank you, our son thanks you, and my husband, Nickolas Wildstar, thanks you. So in addition to that, I'd like to make my recommendations for sentencing. Your Honor, the state has asked for 180 days jail time, and we feel like this is inappropriate based upon the conviction. These are for contempt of court charges. As you know, there's non-violent charges. There was no violence exhibited, no weapons, no aggravating circumstances exist in which jail time is appropriate. However, if the court is inclined to issue jail time, we do ask that it be a suspended sentence and that there is an implementation of probation from 2 to 3 years. In addition, we ask that the court consider community service as part of that suspended sentence, or in the alternative, Mr. Wildstar will be willing to participate in a work release or pay a fine in exchange for jail time. If the court is inclined to not do a suspended sentence or impact jail time, we do ask there is credit for time served, as he did serve 7 days or 10 days? 9 days in community, 9 days in the Orange County Jail back in December of 2019. And we do believe that that should be considered. Also, we have filed, or we will be filing today, a notice of appeal on this matter. And so we do request that he be allowed to remain out on bail pending that appeal. As noted in the letter, Mr. Wildstar does have a young son who 6 months in jail, 180 days would deeply impact him and his development. Additionally, we are in the times of COVID, and we just believe that it would be unsafe for Mr. Wildstar to be placed into county jail at this time because of the COVID pandemic. With that, if the court does not have any questions, I will submit.
All right, do the people want to respond to either of those comments? All right, there's a couple things that I want to clarify because I think there's some confusion. Mr. Wildstar, in your testimony, you cited Penal Code Section 148G, which is a penal code section that does permit video recordings in response to an arrest for a 148A violation of the Penal Code. And it is not applicable to the situation of an unauthorized video recording in court. So it is not an excuse and it's not a defense. And being mistaken about the law, as you heard during the jury instruction, is not a defense to the charges that the jury found you guilty of. And to be clear, the convictions in the case were not solely for unauthorized recordings in court. The jury found you guilty for disorderly, contemptuous, or insolent behavior during open court in the immediate view and presence of the judicial officer, which is a violation of Penal Code Section 166A1. And they also found you guilty of committing a breach of peace, noise, or other disturbance directly tending to interrupt the proceedings of the court a violation of 166A3. And those willful and deliberate actions didn't occur just once, but on 3 separate occasions. I will note during the entire course of the trial in this case, your behavior has been exemplary. You have been courteous and polite, and I appreciate that, Mr. Wildstar. And that's how we expect everybody to behave in court. This is not a case about freedom of speech or constitutional rights. It's about adherence to the rule of law. And whatever your views are about a particular law, whether you agree or disagree with it, it is essential to maintaining a functioning, orderly, and peaceful and just society that we obey the laws. And just as when we're all driving around on the highway, we have to obey the traffic laws in order to ensure our safety and the safety of everybody else on the road. We have to abide by the laws that require respect and decorum inside a courtroom to ensure that the court is able to carry out its responsibilities under the law, and that everyone who comes before the court is treated fairly, appropriately, and justly in accordance with the law. So I just wanted to make that clear because there have been comments made that make me feel, Mr. Wildstar, like you may have misunderstood your rights in these situations. And I hope now, after having been through this process, that you now have a better understanding of what is expected and what is appropriate and what is legal when you're in a courtroom. After hearing and considering the respective presentations of counsel, the briefs and the exhibits submitted by counsel, the defendant's statement, and the correspondence from the interested persons, as well as the arguments and information presented at this hearing, imposition of sentence is suspended. Mr. Wildstar is placed on 1 year of informal probation. The conditions of probation are that you violate no laws, that you obey all orders and rules of the court, the probation department, and jail, and disclose your probation terms upon request of any law enforcement or probation officer. Pursuant to Rule of Court 1.150, do not record, photograph, or broadcast court proceedings without prior written authorization ordered by the judicial officer at that proceeding. You're ordered to serve 30 days in the county jail. You'll be given credits of 9 actual plus 9 good time work time for a total of 18 days. The remaining jail time is stayed pending your successful completion of 40 hours of community service. And I will permit you to do the community service in Fresno County, and you may have until September 10th, 2021 to complete that community service. You're ordered to pay the mandatory state restitution fine of $150 pursuant to Penal Code Section 1202.4B1, the probation revocation fine of $150 pursuant to Penal Code 1202.44, the $30 criminal conviction fee pursuant to Government Code 70373A1, the $40 court operations fee pursuant to Penal Code Section 1465.8, and you'll be ordered to report to collections on your departure today to set up payments or a payment plan if you want to do that, or a future date to pay those. Do you have any questions about any of the terms and conditions of probation, Mr. Wildstar? And do you accept those? All right. You do have a right to appeal from the judgment of this court. If you wish to appeal, you must file a written notice of appeal with the clerk of this court within 30 days. And unless your attorney files that notice of appeal, you must file the notice if you want to appeal yourself. The notice of appeal should specify what is being appealed, whether it is simply the judgment of the court or the entire proceedings leading to your conviction. If you appeal and you are unable to hire a lawyer, the appellate court will appoint a lawyer to represent represent you on appeal at no cost to you, and you will have the right to a free transcript and record of the necessary proceedings in this court. You must keep the appellate court advised of your current address, and the written notice of appeal must be timely filed. Do you have any questions, and do you understand your appellate rights?
No, the notice of appeal will be filed today. Your Honor.
All right. As far as clarifying, counts 2, 4, and 6 are sentencing on those as stayed pursuant to Penal Code 654, and on counts 1, 3, and 5, that is the court's imposition of a probationary sentence. Bail is exonerated. Good luck, Mr. Wildstar. Hopefully, this has been a learning experience for everyone, and that any future court appearances that you make won't result in this sort of thing happening again. All right? All right. Thank you, counsel.
Your Honor. Thank you, counsel.